पहला बहुत ज़्यादा जो भी होगा सही नहीं बना, बस भेज देना।
ओम रुद्राक्षाय नमः ओम महासनाय नमः ओम अनादितराय नमः पुष्कराक्षाय नमः ओम महास्वनाय नमः ओम अनादितराय नमः रुद्राक्षाय नमः ॐ महासनाय नमः ॐ अनादितराय नमः
एक कोड बाकी है क्या?
इसका एक निकले दूसरे पेज का बाकी है, ऐसा कुछ नहीं।
नहीं, इस यहाँ पे इसमें पीछे काला काला क्यों दिख रहा है मिट्टी मिट्टी? इनके वो वाला काम बचा ना, वो जो ये इसका बचा ना, वर्टिकल गार्डन वाला लक्की का।
हाँ वो लेके जाएंगे आज नीचे सरपंच ने बोला था।
कटेगा बस, ठीक है, कट गया, कटा।
December in Srinagar, and sir has been kind enough to bring me to Mumbai.
So from the
Srinagar to Mumbai.
winter of Srinagar, you have come to the heat of Mumbai now.
Yes. सर यहाँ पे रिमोट किधर है सर ये रिमोट से वो एकदम थोड़ा थोड़ा दूर ये बीच से खुलेगा ना दोनों तरफ और थोड़ा और पीछे बस हाँ नहीं तो वो फंस जाएगा वो वहाँ तक आएगा do the honors.
Please come. Devan, join us. Ranjit, come.
Sir.
Everybody else come. Advocate Jani, students and Jani. All the members should also join. Sir, please come here.
Yeah, please come. Sir, this side. Sir, this side. Sir, this side. Yeah, fine.
Now आप लोग अंदर जा सकते
Devan, come. Please come. All the members come.
Excuse me, sir. 1 second. Just a minute.
बस हम लोगों यहीं तक है बस
हेलो नहीं जाने
सिक्योरिटी वाले तो जाएंगे
नहीं मिल रहा
चलो बस अब वी विल गो टू पटकर हाल यू विल गेट
Hey, check test.
अच्छा अच्छा
Good afternoon. Today we had the honor of our new office premises being inaugurated. Good afternoon. Auspicious hands. Today we had the honor of our new office premises being inaugurated. Chief Justice of India. At the auspicious hands, presence of the Honorable Dr. Justice D.Y. Chandrachud, Chief Justice of India of the Bombay High Court. Presence of the Honorable D.G. Vyas, Mr. Justice Devendra Kumar Upadhyay, the Chief Justice and Dr. Birendra Saraf, Bombay High the Advocate General, Mr. D.G. Vyas, the Additional Solicitor. The new office premises is more than just a physical space. It's a sacred place where the new will find its sanctuary. Is more just a physical space. Would be sought and served. It's a sacred place. We are grateful. Truth will find its sanctuary. The Honorable Mr. Justice Ranjit More, would be chairman of the tribunal. The Honorable Mr. Justice M.G. Sevlikar, the head of the Department of the Mumbai Bench, chairman of the tribunal. The Honorable Mr. Justice M.G. Sevlikar, the head of the Department of the Mumbai Bench, and also the members of the Mumbai Bench for making this event possible. Judges of the High Court of Bombay. I would now request the dignitaries to light the lamp, making this event possible. I would now request the dignitaries to light the lamp.
गणनायकाय गणदैवताय गणाध्यक्षाय धीमहि गुणशरीराय गुणमण्डिताय गुणेशानाय धीमहि गुणातीताय गुणाधीशाय गुणप्रविष्टाय धीमहि गुणातीताय गुणाधीशाय गुणाय गौरीतनयाय धीमहि गजेशानाय भालचन्द्राय श्रीगणेशाय
We are extremely honored to have His Lordships, Dr. Justice D.Y. Chandrachud, as our chief guest today. Extremely honored to have His Lordships, Dr. Justice
Graduated in economics with
as our
honors
chief guest today.
from St. Stephen's College in Delhi and completed his
Graduated
law
in economics with
from
honors.
Delhi University. From St.
His Lordship
Stephen's
thereafter
College
completed Delhi.
his LLM
Completed
in
his
1983 from
and
Delhi
doctorate
University.
of juridical science
Lordship in 1986, both
his
from
LLM
Harvard
in
University.
1983. His
And
Lordship
doctorate
was
of
appointed
juridical
sciences
not
in
only as an
1986,
additional Solicitor General
both
of
from
India,
Harvard
but
University.
also as a designated senior
His Lordship
advocate
was appointed
at an extremely
not only
young
as
age
an
of
additional
39
Solicitor
years,
General of India,
but also
Justice
as a
Chandrachud
designated
began his
senior
judicial
advocate
career
at an
in
March of
young age
2000
of
as an
39
additional
years.
judge of the High Court of
Justice
Judicature at
Chandrachud
Bombay.
began his judicial career. He was
Thereafter
thereafter
appointed as the
an
Chief
additional
Justice
judge
of the Allahabad High Court of Judicature at
in
Bombay.
October of 2013. He was thereafter
and then
appointed to the
as
Honorable
Chief
Supreme
Justice
Court in
of the Allahabad High
2016.
Court.
In October
Finally,
of
Justice Chandrachud
2013,
came to be
and
appointed
then
as the Chief
to the
Justice of
Honorable
India
Supreme Court in
November
2016.
of 2022. Finally, Justice Chandrachud came to be appointed as the Chief Justice of India
Justice
in
Ranjit
November
More,
the Chairman of the Central Administrative Tribunal,
May I
to
now
present
request the Honorable
Chief Justice Dr. D.Y.
Ranjit
Chandrachud
More,
with a token
Chairman
of our
of the Central
gratitude
Administrative
Tribunal to present Chief Justice Dr. D.Y. Chandrachud with a token of our gratitude. We are also extremely privileged that the Honorable Mr. Justice Devendra Kumar Upadhyay, the Chief Justice of the Bombay High Court, has graced this occasion. Extremely privileged. Justice Upadhyay has graduated in law from Lucknow Lucknow University in 1991. Thereafter, Justice Upadhyay, Chief Justice, graduated in law from Lucknow and flourishing law practice University in the Allahabad High Court. His lordship was appointed as the Chief Standing Counsel for the state of UP in the year 2007 and continued as such until he came to be appointed as a judge of the Allahabad High Court in 2011. He has since come to be appointed as the Chief Justice of the Bombay High Court on 29th of July 2011. May I now request the Honorable Mr. Justice Chief Justice Sevlikar, the head of the Department of the Mumbai Bench, to present a token of our gratitude to the Honorable Mr. Justice Devendra Kumar Upadhyay, the head of the Department of the Mumbai Bench, to present a token of our gratitude to the Honorable Mr. Justice Devendra Kumar Upadhyay. We are also delighted to have with us Mr. Devang Vyas, the Additional Solicitor General of India. Mr. Devang Vyas was appointed as an Assistant Solicitor General of India at a very young age of 37 in 2014. Mr. Devang Vyas was appointed. Mr. Vyas was also appointed by the state of Gujarat of India at a very young age of 37 in very important cases before the Honorable Supreme Court. Mr. Vyas was also appointed as a special counsel before the commission headed by Mr. Justice G.T. Nanavati. Before the Honorable Supreme Court was appointed as an additional Solicitor General of India in 2023 and has since been holding dual charge for both Bombay and Gujarat High Court. Was appointed as an additional May I now request Honorable Srimati Harvinder Kaur Oberoi, Member Judicial, present for both Bombay and Gujarat High Court, token of her gratitude. May I now request Honorable Srimati Harvinder Kaur Oberoi, Member Judicial, to present Shri Vyas with a token of her gratitude. We are also delighted to have with us Dr. Birendra Saraf, the Advocate General for the state of Maharashtra. Dr. Saraf, as we all know, has been extensively practicing in the Bombay High Court. Though Dr. Saraf has, with his characteristic humility, requested me not to spend time on highlighting his achievements, nonetheless, I would be remiss if I do not mention that his professional achievements are a legend. May I now request the Honorable Sri Krishna, Member Administrative of the Mumbai Bench of the Tribunal, to present Dr. Birendra Saraf with a token of our gratitude. May I now request the Honorable Member Rajinder Kumar Kashyap of the Mumbai Bench to present a token of gratitude to the Honorable Mr. Justice Ranjit More, the Honorable Chairman of the Central Administrative Tribunal. May I now request the Honorable Mr. Justice Ranjit More, the Chairman of the Honorable Tribunal, to commemorate today's events, to commence today's events.
Honorable the Chief Justice of India, Dr. Justice Dhananjay Chandrachud, Honorable the Chief Justice of the Bombay High Court, Devendra Kumar Upadhyay, Mr. E.G. Vyas, Additional Solicitor General for Gujarat and Maharashtra, Mr. Birendra Saraf, Advocate General for Maharashtra, sitting judges of the Bombay High Court, former Chief Justices, former judges of the Bombay High Court, senior designated lawyers, the staff of the registry of the CAT, and ladies and gentlemen. It's indeed a matter of great pleasure and privilege to address this august gathering. In inauguration ceremony of new office cum court premises of Bombay Bench of the Central Administrative Tribunal. In 1985, both the houses of the Parliament passed Administrative Tribunal Act, and President gave assent on 27th of February 1985. Thereafter, Act came into force from the 1st of July 1985, and actually tribunals were established from 1st of November 1985. Initially, there were 5 tribunals, 5 benches of the tribunal, including the principal bench at New Delhi. Bombay Bench was among those 5 tribunals. Now today we have 19 benches and as many circuit benches with the strength of 70 members, inclusive of the chairman as head of the institution. In the year 1991, Bombay Bench was from Bombay to area because of the reasonable demand from the state that the seat of the tribunal should be in near vicinity of the High Court. Since then, the premises was commenced in the rented premises and we were in search of suitable alternative accommodation. We were making efforts. Now those efforts have borne the fruits and the central government allotted new premises in Nishta Bhavan. Now it is ready for occupation from Monday from the bench will start its working from the new premises. Since inception, the institution of the cases in the tribunal has kept its place. Quantitatively, the cases in the filing of the cases in the tribunal has increased. We are trying our best to give qualitative and quantitative justice. If the writ jurisdiction is available under Article 226 of the Constitution of India to challenge the order of the tribunal, naturally some orders would be reverted. But I can tell you with confidence that by and large we are able to do justice qualitatively and quantitatively. To illustrate, we have a data. Out of more than 6 lakhs of the cases, only 59,000 cases were carried to the High Court. That is less than 10% of the cases were challenged in the High Court. Out of these 10% cases also, success rate is nearly about 70%. So it means that 70% decision of the tribunal were confirmed in the High Court. So I can say that with confidence that we are able to discharge our duty, and we have also reduced the burden of the High Court so far as the service litigation is concerned. Infrastructure-wise, we have 19 benches, and out of 19 benches, we have one building in the building for the 9 benches. So far as the other 7 benches are concerned, we have the premises are made available either by the respective state government or CPW, Central PWD. So far as the Chennai is concerned, the Honorable High Court of the Madras has given some premises on rent. And other premises, places at 2 places, namely the Guwahati and Lucknow, the buildings are under constructions. So infrastructure-wise also we are doing much better. And within 2-3 years, we are confident that every bench of the tribunal would be housed in good building, so as to enable us to dispense the justice to the litigant. Now, in accordance with the policy, national policy adopted at the instance of the Supreme Court, we have also put in the place the advanced case information system. This is in order to prepare the Indian judicial system to face the new age, that is technical age, new age. We are also given the facility of e-filing. Now lawyers and litigants, they can file the cases through e-model. The facility of virtual hearing also is made available to everybody. So any person, the litigant can file the document, upload the document, and he can also access the document. Of course, document should be related to the case. So this e-filing and the virtual hearing is that facility is given to the lawyers and litigant alike. To part with, I place on record my deep gratitude to the Chief Justice of India and the other dignitaries for sparing their invaluable time to attend this function. I also congratulate and thank the CPWD, and especially the Chief Engineer, Mr. Rai Chaudhary, for his consistent effort in renovating and refurnishing our premises so as to make the premises, the function, the tribunal smoothly. I know that everybody is eager to hear our beloved Chief Justice of India. I will stop here. Thank you. Jai Maharashtra.
I now request the Honorable Chief Justice of India, Dr. Justice D.Y. Chandrachud, to ennoble this occasion with his always inspiring words.
Honorable Chief Justice of the Bombay High Court, Justice Devendra Kumar Upadhyay, Honorable Judges of the High Court, I particularly thank all of you for rushing from court here to be with me this evening. Former Honorable Judges of the Bombay High Court, your presence has really moved me emotionally this evening because all very dear friends with whom I have such old and long memories. The Advocate General of Maharashtra, Justice Ranjit More, Chairperson of Central Administrative Tribunal, all the other members, Mr. D.G. Vyas, Additional Solicitor General of India, office bearers of the Bar Association, members of the bar. First and foremost, I would like to applaud the chairman and the office bearers of the Central Administrative Tribunal for their efforts in securing this office space. My heartfelt thanks and appreciation of the work which has been done by the CPWD branch in setting up this office. As any Mumbaikar can testify, the troubles of securing spaces in Mumbai are well known. We just used this opportunity 15 minutes ago to judicially hold the Advocate General of Maharashtra to ransom by demanding that our dream of setting up the Bombay High Court in new premises is fulfilled at an early date. And like every good Advocate General, he owes his loyalty first to the High Court and then to the government. Talking about the difficulty of finding spaces, I didn't have that kind of a difficulty when I was a lawyer. I had a massive office when I was a lawyer. And my office was about 120 square feet. And in that 120 square feet, we all packed in half a dozen juniors, me, and ever so often my juniors would come into the chamber. And I later on realized that they would come into the chamber more for the air conditioning than for the exchange of ideas. I don't know what happened. We produced one Advocate General and a judge of the High Court, and not to mention a senior counsel in the cooperation of the government. Very often we forget the importance of the work which the government does in aiding and supporting the judicial infrastructure. I must say, in the interest of full disclosure, that events such as these inaugurations of new benches and new court complexes always make me feel nostalgic about my own time as a lawyer. That's why I began about my beautiful, the 120 square feet office. I had the great good fortune of appearing before the Central Administrative Tribunal when it was situated in the insurance building. I would go there ever so often, appear before the Central Administrative Tribunal. Later in my years as Additional Solicitor General, I went very, very often to the Central Administrative Tribunal. I'm confident that the young members of the bar and the bench will put these additions to our courts and tribunals to great use. I'm confident also that this office complex will add tremendous value to the working of CAT and the experiences of those approaching it. With that hope, I would like to address you briefly on an issue that is very close to my heart. That is the issue of accessible infrastructure and access to justice. The Central Administrative Tribunal was born out of the 42nd Constitutional Amendment. Many of you are much younger. Some of you are older, and I'm happy to find people who are older than me in the audience as well. So it was born out of the 42nd Constitutional Amendment, which was, one of the objects was to combat the delays and backlogs which were faced by our courts. It was hoped that these tribunals, which were untethered by the strict rules of evidence and procedure, would help unclog the courts and aid overall in the dispensation of justice. The Central Administrative Tribunal has grown multifold since its establishment. As Justice More just told us, 19 benches and 19 circuit benches across India, with approximately 9 lakh cases which have been instituted. Most of these cases, I must add, have been successfully disposed of, which is a unique achievement for a tribunal, because our tribunals by and large are plagued with problems. And then we ask ourselves, was it really necessary to constitute so many tribunals? Because you don't get judges. When you get judges, vacancies arise which are kept pending for a long period of time. And there is this constant tussle about who will have ultimate control over the appointment of judges. Then again, initially it was postulated that appeals from the Central Administrative Tribunal would come directly to the Supreme Court, which meant that somebody who has been suspended or someone who was transferred from station A to say station B, and whose spouse was suffering from a terminal disease, had to come all the way to the Supreme Court against an order of the Central Administrative Tribunal. That was replaced, of course, after the Supreme Court held that the writ jurisdiction of the High Courts will not be excluded. In the Bombay High Court, we have a particular affinity to the Central Administrative Tribunals because two of our own colleagues have risen to become chairpersons of the tribunal. Justice Ashok Agarwal, who was such a fond member of our bar and bench, and now Justice Ranjit More. Both judicial and administrative members have complemented the work of the Central Administrative Tribunal. As I was just speaking to Justice More a short while ago, we judicial members, our knowledge is by and large based on books, on service law, and our experiences in conducting litigation for our own clients. But the administrative members have a real feel for grassroots reality in the service of the central and the state governments. So this combination of the judicial and administrative members has really strengthened the Central Administrative Tribunal by bringing together the wide experience in litigation of the judicial members. Many of them have wide experiences, members of the district judiciary. They bring a sense of continuity. And you have the administrative members who have a real understanding, an understanding of the difficulties which people who are in service face. So from being effective alternate substitutes to the high courts, the tribunals came to be recognized as supplements to the functioning of the other courts. The tribunals have assisted courts of the country by redirecting service matters, among others, towards themselves. But this is not all. The tribunal has afforded a shorter route to certain categories of litigants. A longer legal battle is bound to become more onerous, perhaps more for one party than the other. The delays in litigation always tends to impact one party more than the other to a dispute, regardless of the individual merit of the case. For instance, a rightful but weary pensioner or a wrongly terminated single mother may not withstand a long and winded litigation, as well as outlast her much more powerful opponent, usually the state, in a long-winded legal tussle. She may continue to have both the substantive right and the right to enforce it, but the prospect of a prohibitively long and costly legal battle may stifle the right at the very outset or overshadow the right in the course of the journey. So the very existence of administrative tribunals is premised on their ability to make this journey less onerous for litigants in matters of public employment, which I believe that they have. Recently, we held a conference of all the Chief Justices of the High Courts on the occasion of the Constitution Day, when we set up the statue of Dr. Babasaheb Bhimrao Ambedkar in the precincts of the Supreme Court. A report was prepared by the Center for Research and Planning of the Supreme Court called The State of the Judiciary. And this report highlights the infrastructural gaps in the judiciary. The report found that for the sanctioned strength of 25,081 judges in the district judiciary, there is a shortage of 4,250 courtrooms and 6,021 residential units. Notably, 42.9% of the total courtrooms have been under construction for more than 3 years. In contrast to that, this new building of CAT, the 2 floors, represents our continued efforts to work towards more inclusive, accessible, and just institutions. While accessible institutions are a goal in themselves, they are also a means to a goal, a means to an end. We know that the barriers that stand in the way of access are many: social barriers, physical barriers, or systemic barriers. The purpose of the infrastructure of our institutions should be to mitigate these barriers for a meritorious legal dispute to be heard. For instance, the inability to get a timely outcome may impact the practice of a male as well as a female lawyer. Everything else being equal, in a society that associates intellect and caliber with gender, the impact of delay will be greater for the woman lawyer than for a male lawyer. She is not only fighting her immediate opponent in court, who perhaps benefits from the delay, but is also combating years of gendered perceptions about her innate ability to be a lawyer, a profession often incorrectly linked with unemotional rationality, not typically attributed to her gender. A delayed delivery of outcomes would weigh much more heavily on her than it does on her male colleagues. Similarly, the impact of professional losses due to the delays and costs of litigation is more pronounced on a lawyer who is a first-generation lawyer than it is on others who have the safety cushion of a generation social and financial capital. The identical, facially neutral problem of delay could have disparate impacts on different people. At a certain level, we feel that delay affects everyone equally, but that is not so. It's facially neutral, but it has a disparate impact on different people for reasons rooted in social barriers rather than merit. Accessible institutions can in many ways level social and other imbalances by accounting for such social and other barriers. Women, however, have been performing against all odds in the legal profession in India, and Maharashtra is no exception. The State of the Judiciary report found that out of 16 states which recently conducted the Civil Judge Junior Division recruitment process, 14 states had more than 50% selection of women judicial officers. In some states, even in the absence of a horizontal 30% reservation, the number of women who are being recruited at the lowest level of the Indian judiciary has gone up to 70 or 80%. Therefore, our processes and infrastructure need to be architecturally inclusive to address the challenges as well as the changing composition of the legal profession. Look around you today. When I was at the bar, you wouldn't have this large presence of women lawyers in any auditorium. But that has changed. And I do believe that tribunals like the Central Administrative Tribunal, apart from the fact that they render justice and service matters, have a very vital role to play in the development of our own bar, in creating more opportunities for argument, which are not necessarily available in the superior courts. This lies at the very core of reasonable accommodation, which runs through the fundamental rights which are guaranteed by our Constitution. In the context of rights of persons with disabilities, we have reiterated that the freedoms and the right to life will ring hollow if they are not given additional support that helps make these rights real and meaningful for them. I remember just a few years ago, there was a judgment which said that becoming a judge is not something which is open to a visually challenged person, a blind person. That judgment was reversed several years later, but have we created adequate opportunities for the visually or the physically challenged to access our court spaces? As courts and tribunals, we cannot immediately wipe out the impact of these inequalities in our society. We must, however, strive to bridge the gap between people across the spectrum of inequality as far as legal outcomes and processes are concerned. One way of doing that is to ensure that our infrastructure is inclusive and affords the requisite support systems. I was therefore very happy to learn from Justice Ranjit More's brief address of the rapid steps which have been taken by CAT in ensuring that technology is incorporated in the system. Physical infrastructure can include many things that go beyond the four walls and roof of a courthouse, such as the judge's bench, podiums for lawyers, witness boxes, judges' chambers, registry, and other offices. Years ago, and I'm not talking of 3 decades ago, just a few years ago, when Justice Abhay Oak and I were administrative judges for Kolhapur, Justice Oak and I visited Kolhapur to inspect the infrastructure, and we were told that there was no bathroom in the district court for women judges. And there was a very senior additional district judge who said that, sir, there are women here today who are 28 or 30. They come early morning. They can't go to the only toilet which is earmarked for women because they have to pass all the under trials. So they say we find it extremely because they jeer at us, they look at us. The next visit to the bathroom is at 6 o'clock in the evening when they go home. That was the reality of even a developed state, as we call our own state, the state of Maharashtra. So this is something which we really need to look at. Accessibility includes features to enable access and maneuverability, such as ramps for the disabled, elevators, and signages in different languages. I understand that in cities like Mumbai, it is very difficult to remodel courtrooms to make them accessible to the disabled. But surely the conversation must begin, however difficult it is to achieve the desired outcome. A report in 2018 has surveyed the state of infrastructure of courts and found that there were significant physical infrastructural gaps in the availability of ramps, lifts, waiting areas, help desks. The Supreme Court Center for Policy Research report just published last month has found that only 13.1% of the district court complexes had child care rooms. Only 50% had ramps with persons for disabilities. The report found that 40% of courts had dedicated places for persons with disability, and only 30% had infrastructural support in form of tactile paving. Recently, I had requested Justice Ravindra Bhatt of the Supreme Court to chair the Accessibility Committee. The report of the Accessibility Committee of the Supreme Court of India highlighted the issues faced by persons with disabilities, women, particularly during pregnancies, as well as senior citizens in accessing courts physically or digitally. Most of the people who will come here in search of pensions are senior citizens who have lost their employment, who have retired. The committee has provided a series of actionable recommendations: accessible route maps, pathways, accessibility of documents, regular updates on fresh matters, assistive technology to navigate the court website, and various other accessibility improvements across court complexes. Let me briefly speak about technology, which is very close to my heart. Technology must foster the relationship that litigants share with courts. However, we must remember that it can never become a condition in accessing justice, the sole medium to access courts. Physical access to courts can never be understated in its importance and must be constantly improved. It is no answer to a wheelchair-using litigant, a senior citizen, or a lactating mother for our courts to tell them that our courts are better experienced online. The gains of such state-of-the-art technology must supplement and not sabotage physical access. The litigant alone must have the choice of how they want to access the courts. Our function as courts and tribunal is to give them an effective choice between a fully functional and accessible physical court complex and an equally efficient technology-enabled court. As the old saying goes, justice must not only be done, but it must be seen to be done. As institutions founded upon public faith, our infrastructural advances must be guided by the objective of accommodating people with diverse needs from diverse segments of our society. Enhancing the quality of the infrastructure of an institution also influences public perception and trust in our work. Well-maintained and accessible infrastructure can enhance the public's confidence in the state's ability to meet not only their legal needs, but also account for their comfort as they navigate through the complexities of these daunting legal journeys. A very distinguished Japanese architect who redesigned the Museum of Modern Art in New York said, "Architecture is basically a container of something. I hope that they will enjoy not so much the teacup, but the tea as well." As members of the bar and the bench, I take the liberty to speak for all of us when I admit that our collective limits in the understanding of architecture are for all of us to see. But we are equally united in our spirit of service. A conversation about infrastructure is incomplete without a tip to a very crucial component of our courts, the people who navigate the other two physical and digital components. I know of many lawyers who would not shy away from going above and beyond in the discharge of their professional duties. I similarly know many of the judges who work tirelessly to leave their courts better than how they found them, and that includes all the former members of the High Court who are here. They have dedicated their life in the mission of serving the cause of justice, when they could have spent their lives earning tons and tons of rewards that lie outside in the profession. So it is not just in terms of their jurisprudence that the judges have contributed, but also in terms of their institutional legacy, which goes beyond the case law which they have contributed to. We have in many ways come to redefine justice in terms of accessibility, in addition to its principled outcomes. As a court of precedent and sometimes as legal scholars, we do indeed stand on the shoulders of our own colleagues and ancestors in the judiciary who preceded us. The court's personnel infrastructure comprises not only of our lawyers and judges, but also our registries, support staff at all levels of courts form the basic or the backbone of our system. In the Supreme Court of India, we have launched upon a calendar for training the entirety of our staff. Because it is important that we train our staff. We must help them aspire for career advancements. Their efforts often go unseen by the public eye, but I must say that many cogs of the machinery of our courts must fall right into place as they do for them to run smoothly. Courts, tribunals, and every single person who works towards improving them essentially function as the vessels of justice. We are not just the container, but also what lies inside the container. For facilitating and fostering social cohesion by addressing grievances and disputes across diverse segments of our society. Sometimes in states like Maharashtra, we do not realize the importance of the work which we as judges do in this institution of justice. Having spent now the last 11 years in a place outside my own home state, initially in Uttar Pradesh and now in Delhi, and looking at the entirety of a nation, I realized how blessed we were as lawyers, how lucky we were as judges to be able to do our work in such relative objectivity. As judges, we had a bar which was so professional. I always say that the hallmark of the Mumbai bar in particular, and that's across Maharashtra, is that the lawyers before us don't bother about how you decide a case. All that they care is that you decide the case. Please don't duck the case. If they have a problem, they can go in appeal. As we used to say in the Bombay High Court, if I had a problem before a single judge, we went onto the second floor and got a stay the next day. But that is really, truly the beauty of this state. And I think we should not ever ignore the favorable conditions in which we work as opposed to the rest of the country. There is also a culture of governance in the country where governments successfully have left the judiciary alone. They don't tinker with the work the judges do. They accept outcomes which are favorable, they accept outcomes which are unfavorable, because that is the culture of Maharashtra. But that's something which we must, as individual citizens, be proud of in the work which we continue to do. The office complex that we inaugurate today is named Nishtha, which loosely translates to faith, a sentiment I am sure it will reflect in its functioning. I am certain that it will serve as an effective vessel in discharging the functions of the Central Administrative Tribunal Mumbai and will enhance greater access to the tribunal. Once again, I would like to thank Justice Ranjit More, my very fond former colleague of the High Court of Bombay, for inviting me. And I would like to congratulate everyone who has made this day possible. My compliments to the bar, and I'm sure you will use the 2 floors to produce justice not only of quantity, but of good quality. Thank you.
May I now request the Honorable Mr. Justice M.G. Sevlikar, the head of the department of the Mumbai Bench,
to kindly deliver a vote of thanks.
I have the pleasure of proposing the vote of thanks for today's function. First and foremost, we are truly fortunate to have His Lordship, Honorable Dr. Justice D.Y. Chandrachud, the Chief Justice of India, amongst us as the chief guest of this function. Being in the legal profession, we all know His Lordship as the Chief Justice of India, as a jurist and a legal luminary. What many of us don't know is that His Lordship is a very versatile personality. In addition to the law, His Lordship has a keen interest in music and trekking. He also worked as a radio jockey in All India Radio. It is a very special day for all of us to have His Lordship amongst us, and I am extremely thankful to him for accepting our invitation with his presence and providing his guidance, and this will be a beacon of light for all of us. We are blessed to have His Lordship for today's function. I, on my behalf and on behalf of Honorable Chairman, Sri Justice R.V. More, and his companion members of the Central Administrative Tribunal and all the staff of the Central Administrative Tribunal, extend very warm and sincere thanks to His Lordship for taking his time out of his busy schedule and gracing this occasion. I am also thankful to His Lordship, Honorable Sri Justice Devendra Kumar Upadhyay, Chief Justice of Bombay High Court, for taking his time out of his busy schedule and gracing the occasion. I am also thankful to Sri D.G. Vyas, Additional Solicitor General of India, for accepting our invitation and gracing this occasion. I am also thankful to Dr. Birendra Saraf, Advocate General, State of Maharashtra, for accepting our invitation and gracing this occasion. I am also thankful to Honorable Sri Justice R.V. More, Chairman, Central Administrative Tribunal, without whose support this renovation and shifting of premises would not have been possible. Because of his incessant efforts, renovation and shifting has been possible in such a short period of time of his taking over as chairman. I am also thankful to all the honorable sitting judges of Bombay High Court for taking their time out of their busy schedule and gracing the occasion. I am also thankful to all the honorable former judges of Supreme Court, former judges, justices, chief justices, and former High Court judges for attending this function and gracing the occasion. I am also thankful to all the members of the tribunal and retired members of the tribunal for attending this function and gracing the occasion. I am also thankful to Sri Fani Bhushan Singh, SDG, CPWD Mumbai, Sri Dev Jyoti Roy Chaudhary, Chief Engineer, CPWD, and his team, Sri Prakhar Tripathi, Chief Engineer, Civil Liaising Officer designed for this particular office, Sri Praveen Kumar Goyal, Executive Engineer, Electrical, for completing the renovation work in time. I am also thankful to Srimati Preeti Singh, Principal Registrar, Sri Sulabh Rastogi, Registrar, Sri Suraj Singh, Joint Registrar, Sri Prakash Joshi, Private Secretary and Protocol Officer, Central Administrative Tribunal, Principal Bench, for attending the function and for assisting us in making arrangements. I am also thankful to President and members of the Bar Association of the Central Administrative Tribunal and Sri R.R. Shetty, Advocate, for participating in this function. I am also thankful to Srimati Dakshita Shah Ashar, Manager, Bamar Lorry and Company Limited, for making these arrangements and for the delicious food. I am also thankful to Sri Patwe, Registrar of this bench, and the staff for making necessary arrangements. I am thankful to the concerned authorities for making Patkar Hall available for this function. Once again, I would like to extend my warm and sincere thanks to all the dignitaries present here and wish everyone good health as always. Thank you.
May I now request everyone to rise for the national anthem, please.
पंजाब सिंध गुजरात मराठा
May I request all the sitting judges, the former judges, to kindly come to the committee room, and also the sitting members of the tribunal.
अभी उसने कट किया क्या देखता हूँ, अभी यहाँ से निकाल दो।